Okay, good afternoon. Good afternoon. This is Dan Felkel. We're here for a seminar on off-duty conduct. Two housekeeping matters. First of all, if you're attorneys, you should do the thumbs up signal on the machine, and Anna Lee Rosenblatt will take your names, et cetera, et cetera. If she has your bar number, she'll submit that to the bar. If she doesn't, she'll contact you. Okay. The second thing is I'm a vice president on the LERA local board, and we're always looking for new board members if someone has an interest, employer side, neutral, or employee side. It's not that much work, but we try to rotate out so people like Shari Broder, who's been doing this 10 years or something like that, can get a break. So I'm an attorney at Troubh Heisler, and my labor work is largely for police officers, 99% on the employee side. We have two presenters, one for the employer, that's John Hamer, who works at Rudman Winchell. He is a partner there. John went to McGill University, and then he went to Vermont Law School, has a master's degree and a law degree. Came out, worked for the city of Bangor for 8 years plus, and then joined Rudman Winchell. And he's stepped in here to help us out today, which is great. John does the regular municipal work you would expect, usually on the employer side. We deal with him in my office, representing police, and he represents the town on the other side of that issue. The other presenter on the employee side is John Chapman. Those that don't know John, he has been an attorney since I think 1980. He was with my old firm, Richardson and Troubh, until that firm broke up, and so that's when we went in different directions. John did a lot of workers' comp work. He also has done for 40 years labor work, primarily with first responders. He is a graduate of Bowdoin College and a graduate of Maine Law School as well. If you can see the screen, you're going to have a 3-page outline there. We're talking about off-duty misconduct, or what I sub-name what you can get away with while you're off-duty without getting in trouble, if that's possible. And I'll start you on page 4 of that document. You'll see something from the El Khoury. Hopefully you'll see something from the El Khoury treatise there on, these are the standards. I used this recently in a case I had. You know, obviously there has to be a nexus from the off-duty conduct to the job. Okay, and so how can you show that nexus? And those are the 4 standards. This is popularly accepted. I'll give you another site for a rephrasing of this. Conduct involving harm or threat to supervisors, co-workers, customers, others with actual or potential business relations with the employer. Now, okay, does that come up in your case? 2, conduct that could seriously damage an employer's public image. That, to me, of the 4 is the one I see most often. 3, conduct that reasonably makes it difficult or impossible for supervisors, co-workers, customers, or others with actual or potential business relations with the employer to deal with the employee. What you have in those circumstances, they've offended a customer, they're hostile to their co-workers, sometimes they're in jail. They can't do their job, and so on and so forth. That comes up. And the 4th one, which we do see quite a bit, public attacks by employee on the employer, supervisor, the employee's co-workers, I don't know what that's, or product. You see that sometimes. We see it more now in social media. When people go home and they go on Facebook and say terrible things about their bosses and all that kind of stuff, and they're off duty, of course. That's happening as well. A second site I'd give you with the Bornstein-Gosling grievance or treatise, and there's a different phrasing of the 4 things: damage to the employee's business reputation or both, unavailability of the employee due to incarceration, impact of the grievance reinstatement on fellow employees, the refusal to work with off-duty offender or potential exposure to dangers from the offender, and finally, unsuitability for continuing employment in light of the misconduct. So that's where you get, it depends on what your business is. If you're a police officer, it's much more stringent, probably fires, et cetera, et cetera. And as you go along, maybe not so important if you're a clerk in a registry of deeds, for example. Not to impugn that at all. But, the public facing jobs, there's probably more pressure on them. If we want to go back to the top and look at the outline, I find in my cases that the action, it's very important. The action must cause actual harm. And then you get to how do you prove harm? And this is a tough thing for employers. I've had cases where they don't really stress that. They don't look at that, don't think about it, because then how am I going to prove that we lost 10 customers today? And then to bring that into an arbitration setting is kind of strange, because what we do, we have, 3 witnesses. We're not talking about, the franchisor in Milwaukee coming in to testify and stuff like that. So I think that's what you run against. That's a burden for the employer that I see. I also got standards are changing. Here's a Cape Coral, that's in Florida. Arbor found that the city failed to establish a nexus between a firefighter's off-duty conduct and the city's legitimate business interest. So he's a firefighter. What did he do? Arrested during an altercation with his girlfriend, did not cause harm to the city's reputation, did not render him unable to perform his duties. It did not result in his co-workers being unwilling to work with him, the arbitrator reasoned. So that's a case from 2018. But there you can see that's fairly mild, but we don't know what he did in this altercation with a girlfriend. He gets arrested. It had to be fairly serious, but applying the standards to off-duty conduct, again, the arbitrator wasn't that worried about it and put him back to work. So I think, maybe getting easier in the cases I've seen over the years on employees going back to work. So just cause, and John Chapman's going to speak to that. John?
Just making sure that I'm not stepping on everybody else's toes. The first thing that's important is to look at your collective bargaining agreement, because a lot of this is built in directly and indirectly. I've got collective bargaining agreements that have multiple pages of work rules built into the agreement itself. So there's not much point in claiming that those aren't bargained. And that's a really excellent thing to do. Another important role of the collective bargaining agreement, especially regarding off-duty conduct, is in the area of discrimination. I've always thought it interesting and problematic to have a collective bargaining agreement that requires that the employer not discriminate on the basis of race, gender preference, those kinds of things. And the reason it's problematic is because if you put it in there, the union's going to have to do something about it. If it comes to your attention, somebody may be a victim, you can't just send them to the Maine Human Rights Commission. You are going to have to actually take action yourself. And that's interesting because frequently you're going to be investigating a fellow bargaining unit member. And so it's, I've often said to people, you can have that in there if you want, but it's a lot better and easier if you let the Maine Human Rights Commission do that and just tell people not to discriminate. Whether or not that's going to be in the CBA, the important thing to remember is that unions under both the Maine Human Rights Act and the Equal Employment Opportunity Act can be liable to individuals in the bargaining unit and elsewhere for discrimination. That's specifically written in there. And it happens a lot with discrimination on the basis of disability without it being smarmy. But I think in off-duty conduct, it happens more with race and gender, and in particular, sexual harassment. And sexual harassment is something that it happens as a as a thing often enough. Maybe that is the one exception, to have it written in there, just what you're going to do if that pops up. If it isn't there, there can be truly hell to pay, because these things usually build up and build up. Sometimes it's on duty, but a lot of times it's off. Conduct unbecoming is one of those things that seems to happen mostly off duty. I've got there's probably 2 pages of cases between the state of Maine and the United States District Court in Maine about conduct unbecoming, and it sounds vague, but it's basically stuff that makes the employer seem like it's in a bad light, and that can be done off duty very easily. The piece of that that's problematic is or at least problematic for the employer, is where you're saying bad stuff about the company. And it may be your job to say bad stuff about the company if you're promoting a union or a different union in that company. So you may have to do that. And there's a huge privilege for that. There is one case that stands out in terms of the ability, and I'll give you the specifics of the language later on, but it is an obscenity-laced tirade against a manager that you wouldn't imagine would be tolerated, but the NLRB specifically found in Pier 60 LLC versus NLRB that specifically referring to a specific manager as a, quote, nasty motherfucker, in capital letters, was protected activity under the National Labor Relations Act. Bias is a big problem where you express it outside of work, especially if you're somebody for whom that bias could generate bad stuff for the employer. For example, you're a police officer. If you make bias-related comments outside of work, that can be raised as giglio material. Kind of the law enforcement agency has to provide that to the district attorney, who will then provide it to the defendant as reasons that they shouldn't believe you when you talk about the defendant in that case, because you use the N-word all the time and you have nothing good to say about people of other races. And maybe you're absolutely keeping it between the lines at work, but outside of work, you manifest a lot of bias, and that will bite you at trials. Let me see what else. I'm just making sure I cover everything. So those are the observations that I had regarding stuff that needs to be in the contract that's or ought to be considered for inclusion in the contract that's relevant to just cause. Something about just cause ought to be in there if there's agreement between the union and management as to what it ought to be. Conduct unbecoming, I find it's most effective when it's defined. There's a bunch of conduct unbecoming cases where, for example, they talk in a fraternity context. Getting drunk with pledges is conduct unbecoming. Great, you've defined the actual conduct. You're not just using conduct unbecoming. So don't use it as a wastebasket. Use it as the head of the category. Conduct that puts the employer in a bad light, you don't want to agree to that contractually, although there may be times that subsets of that, like disparaging your employer's products. It's one thing to disparage their fairness. It's another to disparage their products. And I, wearing an employer hat in the private sector, have successfully disciplined union presidents for that. And finally, bias stuff, even if the union isn't on the hook to address it as a grievance item, it ought to be addressed in standards of conduct.
And so as we move along on the outline, we often deal with, we're going outside the contract and we're dealing with third-party agencies for people who have certifications. medical professionals, firefighters, police officers. I end up dealing with the MCJAs. Those are my partners. I've had cases where it represent a pharmacist, and you have to go to the agency. I know my partner Bill McKinley, pretty sure he's represented dentists and doctors before agencies. So there's a whole nother world there that you have to be prepared for. And in certain cases, this is through the admin law process, and you don't have that much of a chance at some of those hearings sometimes, because it's a whole different world, and they're not looking at your contract, they're not looking at case law that would involve being a certain professional. They're saying, did you go outside the lines there? John Hamer, do you represent Moni folks in the private sector who can run into trouble here?
Most of my work is with public sector employers. Occasionally, I will get involved with the private sector ones. In terms of these outside types of licenses, as a general proposition, I tell employers to tread very lightly when you're dealing with off-duty conduct. And some of them are very receptive to that, and some of them are not. But in terms of these non-employer licenses, I tend to keep employers away from that and let those other organizations do their thing. And in particular, when it comes to things like Giglio or the MCJA, and they'll do their own investigation, and they'll do their own inquiry. And then after that's finished, then you may or may not have an employee who's able to do the job.
And as a result, you can, I'm not sure what John meant by waiver, John Chapman, he'll explain that to us, but you can get decertified. In the case of police officers, up to 3 years, you can come back and try to get your certificate back. You can get suspensions and so on and so forth. One, not to do a pun, but also licenses, driver's license that we all have. A lot of jobs you need a driver's license. So good, bad, indifferent. You don't have a driver's license, you can't be, I assume, a firefighter or a police officer, EMT driver, paramedic. A lot of those jobs you can't do. Great. Then you have to deal with your employer and what the employer wants to do. We've had cases with OUIs where you're out 6, 10 months, and the employer takes you back. You do all your process, etc. You have to go to your accrediting agency, and police, it's the MCJA. Get them not to decertify you, and so on and so forth. Explain your circumstances and how you ended up in that situation. We've had other cases where you get fired, and it's hard to argue, other than wrongful behavior, and you might have some cases that you can rely on for precedent, that you should be put back to work when you can't do your job. John Chapman?
Sure, and you backed into waiver very nicely, because I think, as you realized, if we meet and we talk about these issues beforehand, but one of the very common off-duty kerfuffles that we run into with police officers and firefighters is OUI. And that can affect one's EMT license. It can affect one's certification to be a law enforcement officer or a corrections officer. But it's such well-traveled ground, and the track records of people in dealing with it have been so good that a lot of times you can get them to suspend a license for the time that somebody can't drive, and they can continue to work, maybe doing office work or something like that. Or in the fire setting, they can swing an axe and haul a hose just fine. They just can't drive the rig. And a lot of times, the licensing agency and that specific kind of off-duty conduct, if you know the agency's history, will give them something other than a D-cert. I can tell you that with the medical profession, and I assume nursing and some of the subsidiary professions and psychologists and the like, substance use is a big issue. And of course, if somebody's listening to Purple Haze and shooting up something that's completely illegal, you're less likely to get a pass than if it's prescription medication that you have some kind of jurisdiction over, that you're abusing in your personal life. But I see a lot of cases where people maintain their license and come back and have kicked the habit and got the monkey off their back. So that's what I was talking about, waivers. They may waive or suspend instead of terminating a license if it's for something like that. And that's where it's really good. Look at the cases that agency has done to see if there's a history of dealing more compassionately with what your person is presenting.
We also have rules and regulations that come into effect. Most professions have different sets of general guidelines, SOPs, or what have you, and you have to look to those, and sometimes look to those when there isn't an answer in the contract. We, of course, on our side, don't want to give that much weight, but if you are a police officer, for example, you sign papers that you read the SOPs when they were issued, have to follow them, and so on and so forth. If there's a problem in the level of the discipline or even the existence of discipline, you have a grievance procedure, you follow that out through the contract, and so on and so forth. I think people do gloss over the fact that a lot of the conduct is off-duty conduct, and it's your time. You could do stuff which is just socially abhorrent. It's none of the employer's business. That's what you're doing. We don't like it. I don't like it, whatever. But it doesn't cross that line into where it's going to have a heavy hit or maybe no hit on discipline rising out of employment. Obligation to report. What do you think of that, John Chapman?
Well, it's one of those things that can cause problems if an employee X sees employee Y smoking crack off duty. If you have an obligation to report behavior to a licensing board, to your employer, to a law enforcement agency, and that sort of thing, obviously you're now into it. You're going to, as a union, again be in the member versus member situation. Maybe there is constitutionally an obligation. People are getting dinged for failing to take appropriate action when they see other employees doing bad things, even if they haven't done anything bad themselves. The classic example is in the Rodney King case, where Sergeant Stacy Kuhn never landed a blow, and he did time. So think about that obligation to report in terms of dealing with misconduct that occurs off duty. Nobody wants to rat out a fellow employee, but if there is that obligation, you want it to be clear. You want it to be in some kind of an SOP. Otherwise, people will be turning it over and over in their mind, and it leads to discrimination claims if somebody handles, if some guy is given a task for off-duty misconduct and a female's not.
And effective zipper clauses?
If you don't have it in the contract, may not be in a position to force bargaining about this. If you don't have anything at all in the contract about employee on employee conduct, and a female employee comes to you with a problem, and it's not something that union per se has done. It wasn't a union meeting. It wasn't the executive board that did it. Somebody who was also a bargaining unit member hit on him at a party and was very unpleasant about it, nasty, and they're uncomfortable about coming to work. That's not something you can make the employer bargain about at that point in time. I think you can point him towards the employer and say, that's who deals with it. You can give them the Maine Human Rights Commission's address, but you really can't, if you've got a good stiff zipper clause in there that management has insisted on, you can't make management do anything at that point in time about it. If you don't have a real zippy zipper clause or none, maybe that's something that is a kind of a newly arising thing that we haven't talked about that needs to be talked about. And you can make management bargain about it then, even though it's midterm.
But we also see, I think especially in firefighters, they work 24 on, 24 off, 24 on, and then they pick up overtime or whatever. But they could be working completely different jobs. You could work, let's say, as a paramedic. You could be working at the same town or in a town next door, and you get in trouble as a paramedic, you're in employment. How does that translate over, if at all, into your primary employment as a firefighter? What do you think?
I think it depends what you do. If it's a violation of a particular kind of reporting that, for example, doesn't affect patient standard of care, doesn't cause anybody to be in danger, it may be isolated to that agency itself. You may become aware of that. Somebody, didn't report that they worked overtime or somehow misreported time. That's not that big a deal. But if it arises to the level of, a licensure issue, then I think you're starting to get troubles. And the nexus that you were talking about at the beginning is more likely there if you're doing the same job for multiple agencies, like the firefighters. It gets different if, for example, you're doing public works for one town and firefighting for another. Stuff that affects patient standard of care, you may see somebody doing a bad job documenting medication for some other town, but it doesn't affect your ability to repair manholes and throw trash and pave highways. So it depends. It depends what that employment is with the other agency. It's almost like there's almost a guaranteed nexus if it's same kind of employment and it's something that goes to the hard and fast quality of the work you're doing. It could kind of resonate outside and fulfill that nexus to the workplace. If it's different employment, it may not.
Turning to sexual harassment, I'll look for John Hamer's thoughts representing employers, because I think that's very high of the mind. For that, you have sexual harassment, of course, on duty, and I see in clauses where it's pinned out, like, for example, purging of discipline. But if you got discipline for sexual harassment, that doesn't go away at all. So we have scenarios where we're going to have on-duty conduct, okay, and that's sort of something else. But also you have off-duty sexual harassment, maybe charges of sexual assault, maybe related to people at the workplace, but maybe not. What do you think of all that, John?
Yeah, I find that most often sexual harassment is something that takes place in both contexts. Quite often it does relate to somebody they're working with, and then it moves into the off-duty sphere, and it continues to occur out there. I think that for the most part, that's where I see these cases coming from, is something that starts in the office and then it just continues everywhere. And that's certainly going to be something that the employer can deal with. If it's something that starts and remains in their private life and it has no relationship whatsoever to the employer, that certainly still raises concerns about the person's judgment and moral character, perhaps. But I think it's going to be much more difficult for an employer to take any action based on sexual harassment that happens outside of the workplace, just because it's not going to be investigated as it would as it happened inside the workplace. And an awful lot of these sexual harassment cases is very factually dependent, and usually the two sides are very, very different. So how it would come to the employer's attention, whether it's brought to the employer's attention through other employees, there's just an awful lot of ways that the facts can get blurred when you're dealing with off-duty conduct that could be sexual harassment. I think that I generally recommend that unless there's some nexus to the employer, that the employer not get too heavily involved in potential sexual harassment that's occurring outside of the workplace. Unfortunately, most of the cases really do cross the border and are occurring everywhere simultaneously, which still creates troubles in terms of investigating for the employer, trying to figure out what's really going on there. So it's definitely an issue.
Yeah, what if you had a case, you know, with we'll get to John in a sec, where people work together, there's no problem in the workplace, but then they go out for drinks after, and one's, you know, a little too friendly, et cetera, and then a week later the same conduct keeps repeating itself, and they're on their own time, it's private, it's not doing the functions of their work, et cetera, you must see those cases coming at you, and you know, when does that move into the workplace for consideration?
Yeah, that certainly can happen, but chances are if there's repeated off-duty conduct like that, it's spilling into the employment sphere on some level. That how it gets reported to the employer is probably the employee who's not receptive to the advances is bringing it to the employer's attention, and then it does impact the workplace. And there is a nexus, because if you've got one employee who doesn't want to work with another employee, then it's the employer's problem. But chances are, if this is happening off duty, it's moving into the on duty context, and the employer definitely has the right to do the investigation and to take actions necessary. I would have to say that would be very unusual circumstances for employees to not bring it in that kind of situation.
And for both of you, we have a lot of cases, Bill McKinley and John Goodman doing in the last year, it seems to me, protection from harassment cases in district court, protection from abuse cases in district court. As everyone knows, those are very easy cases to prove, and judges are not eager to deny someone's initial request for some type of temporary order, and then you come back in 10 days and so on and so forth. How are you handling those, John Hamer, and what is your involvement from the employer's perspective when you know those things are going on across the street?
Well, if an employee comes in with a protection from harassment order, then that does make it very difficult for the employer. You have to do your best to accommodate both parties, because it's not something that's necessarily impacting the employer at that point. Again, if it gets to the point where there is a protection from harassment order being issued or sought by one party, chances are the conduct that's objectionable is going to be brought into the office, and it's going to be impacting the workplace as well as outside. It's just very rare to have a person's private life and work life so separate that it doesn't come into play in that situation.
What about the circumstances where the other party, the plaintiff in the case, does not work at the locus? It's just, you know, someone in his private life and so on and so forth. That must make a big difference, right?
Yeah. For me, it's going to be a very case-specific inquiry to find out exactly what is going on and is it really impacting the employment. As you mentioned, those types of orders are fairly routinely granted, and they may be very serious issues or they may not be serious issues. So for me, it always comes down to treating the symptoms of anything that spills in from outside of work into the workplace. So if the person is working and doing their job and effective, I'm gonna have less concern about it than if it's something that's being impacting the person's employment. Excuse me for 1 second while I cough. All right, so It really is going to depend what the case is, I think, because whether it's going to impact the employer. So I guess that's where I'm going to end it.
John Chapman, anything before we leave that topic?
Yeah, one of the things that occurred to me as we were talking about it is the classification of the public served in a public servant case is going to affect a lot whether it will be a big deal. I'm down here in the council chambers. I've been negotiating for correction officers here in York County. By the way, a fairly problem solving orientation. Everybody was really trying to get to the bottom of things today. But correction officers are not going to run into somebody unless they're already in jail, whereas dispatchers could run into anybody that's in that town or in the surrounding towns. Same with rescue and police. So it might be important. John was alluding to, is it going to have a nexus with the workplace? And unless you can look at the order, you really don't know, because it's important what they're supposed to stay away from and who they're supposed to stay away from. It'd be pretty easy for a correction officer to stay away from anybody who's not in jail in terms of their job. So maybe everybody ought to have it in there that if you get one of these orders against you, you're going to take it into management. And if it doesn't affect your service to the public in a important way, then yeah, that's nice to know about. If you end up violating it and you're in jail, you won't be able to do your job, but we just need to know about it so we'll be able to make sure that it doesn't interfere with the work you're doing for us.
Now, before leaving that in the law enforcement category, a lot of those orders initially say you cannot have weapons. Okay, when you don't have the ability to carry a weapon, you can't be a police officer. And they got no use for it, short-term or long-term, frankly. Moving down, asserted authority and talking about critical speech and changes there, John Chapman.
Yeah, asserted authority. One of the things that happens outside the workplace a lot is people, and this isn't just cops, firefighters, building inspectors, those kinds of people flash badges, flash ID, and try to get people to do stuff based on their claim of authority. And they can end up getting themselves, and if you know that this is happening and don't do anything about it, then get their agency in trouble too. Just strictly on an agency theory, if you know somebody's representing themselves as having a particular status for you and you don't do anything about it, eventually people they deal with are going to be justified in assuming that you have that status. So you're going to be concerned about displays of authority almost across the board in the public sector. Even guys that haul trash, they've got some ability to tell people what to do and not do with trash, cars, and parking even, and stuff like that. So make sure that people know that they can't just flash badges and stuff where they're not entitled to do it. Another for cops in particular is that HR 218 stuff where you can, if you're a cop, you can carry a gun in all 50 states in the District of Columbia with some limits. And if you identify yourself as a cop, you may generate problems and liability for yourself and even your agency. So that ought to be addressed for everybody that's got law enforcement officers working for them. Do you want me to touch on critical speech too?
Yeah, I'll give that. This changed during our lifetime, right? We had Pickering 1968, now Garcetti's
Yep.
from 2006. Anthony Kennedy held that speech by a public official is only protected if it is engaged in as a private citizen, not if it is expressed as part of the official's public duty. So that was a substantial change to law when that occurred. And of course, that's right here where we are in the topic today.
It's going to be more of a just cause issue for all of us that are in the union setting, because we may not have First Amendment protection, but we may have the ability under the National Labor Relations Act to refer to our supervisor As I mentioned earlier, the MF term, you may be able to drop that as protected speech in another advocacy category frequently if it's part of union activity. It's amazing what we can get away with in that regard. So it's not going to be a First Amendment issue if it's something you're doing on the job as part of the job, but it may be a just cause issue.
John Heyman, you see many of these cases? And I guess
I did.
it's sort of like when we started this 40 years ago, and there wasn't social media, right? So it was basically, I'm the head of the garbage union, and I go out there and I swear about the bosses, and and all that kind of stuff. And are you crossing the line? Now you're talking about the actual business of the employer, and do you get in trouble? But today, everyone's online, essentially exercising their rights of speech, usually not very intelligently.
So over the ages, the standard under the NLRB has bounced here and there, and so today there's this very protective case law protecting union-related speech, and I understand that as much as I may or may not agree with it. And so I certainly agree with John from that perspective that an employer may have to deal with a lot of speech that's non-actionable by employees, but it still has to be in the context of some sort of union context. And so employees just can't walk around saying these things for no reason. But in terms of the Pickering case and Garcetti case, I mean, those have very good guidelines for reviewing when a person is speaking as a private citizen versus in the course of their position. And it is very telling, I think, that both of those cases and some main counterparts to these cases continue to say that if you are speaking pursuant to your official position, you have less rights than if you're speaking as a citizen on a matter of public concern. So anytime that you're trying to address speech by an employee, you've just got to be very, very careful. And you have to consider all of those factors. Is it something that's not pursuant to the job? Is it as a matter of public concern? Is it something that's union related? And then really take a look at whether this is something that's worth following up on in terms of discipline. The asserted authority, which we just talked about a little bit ago, is one of those situations, I think, where you absolutely have to take some sort of action and to address that, because that's something that shouldn't be happening. But when you're talking about speech, and especially when you're talking about social media, which we'll talk about later on, then things get far murkier. And I just tell employers to proceed with caution and consult with counsel, basically, because you can get yourself into trouble without realizing it.
And as we look to
one of the things
go ahead, John.
One of the things I thought I'd mention is, and this is where management can sometimes get surprising assistance from the union. It's fine to disparage your supervisor, and it's fine to disparage how you think they deal with employees. But for God's sake, don't disparage our product that management and union make together, or the brand, because you can lose a customer and watch 5 union guys get laid off, and suddenly the union is your ally. And so, it's fine to disparage how your employer relates to its employees. I think that's very clearly protected. But the more broad, just sort of, I'm going to take action to make their life miserable, is something I think employers can take action against and may find some assistance from the union end.
So you have particular behavior, and then you have avenues, at least under the contracts, typically for punishment if it makes it, for written reprimands, demotions, not getting a promotion, termination, et cetera, et cetera. also be impacted by decertification. You might have cases, John Hamer or John Chapman have had where the employee engages in criminal conduct on duty, and it's reported by the employer to officials, and we've had a few of those cases.
I noticed John's name is by there, so I'm going to defer to him on this.
Well, as a management advocate, you know, our go-to is going to be address things with discipline, because that's generally where you're headed first. It may or may not be something that ends up in having discipline be granted. So there are other things that you can do, which may or may not be appropriate under the circumstances. You just have to make that determination. So the top one, promotion or not promoting, you know, certainly if an employee has shown poor judgment in their off-duty conduct, that's something that you might consider when it comes to deciding whether to promote the person or not. But again, you have to be careful to make sure that the off-duty conduct really has reflects on their ability to perform the new job, and is not something that's somehow protected or just irrelevant, you know, something that the employer just doesn't like. But certainly the impact on the employee going forward and seeking a promotion, that's one thing that employees should keep in mind, is that the employer may not forget, even if they may not end up taking discipline for off-duty conduct. Decertification, that, like I had mentioned earlier, I always defer to the outside agency who's in charge of taking those actions. But if a person loses their certification or a license, we know maybe it's possible to keep the person on. You know, I have seen a number of cases where a person has lost their license from DUI or whatever, and they were retained as employees, and it worked out fine. In other situations, it may prevent them from performing the essential functions of the job, which is far more problematic. Depends what the certification is, depends what the circumstances, but certainly loss of certification can have a huge impact, and it may be an alternate avenue to address off-duty conduct. Criminal complaints, it doesn't happen very often, but I have had employers had to refer conduct to the police department to follow up, and that's not a very effective way to address conduct, because it just takes such a long time. Eventually, it should deal with the issue, but that's usually one of a couple different ways of proceeding to address off-duty conduct. Termination, of course, or lesser discipline, that can certainly be used as a penalty, as a way to address off-duty conduct. Lawsuit for damages. You know, I did a quick search for lawsuits by employers against employees, and you generally don't see them. Usually it's the other way around. So theoretically, I guess it would be possible to try to sue an employee, but I've never seen it, and I probably wouldn't recommend it. It would have to be an extreme case for something like that to even be considered. So there are a variety of ways to address off-duty conduct. Not all of them are discipline. I think the most effective is discipline or non-disciplinary counseling. If there's something that's going on, you don't necessarily have to jump straight to discipline. There are other ways to get your message across.
Have you had anyone ask you, you know, someone does boneheaded stuff off duty, and yeah, everyone knows about it, everyone kind of agrees it's stupid. And in considering the employee as employee, they put that in the performance evaluation. And that could even lead to the promotion idea. Well, you know, it's written somewhere, it's not written somewhere, but he was a bonehead, and we're not going to give him a promotion. It just, you're sort of crossing lines here, right?
Yeah, performance evaluations, it may or may not be appropriate to have non-duty conduct referenced in your employment evaluation, which that's primarily designed to inform the employee how they're doing in their work. But if what they do off duty expresses illustrates such a lack of judgment, then I suppose it could show up in a person's employment review. I probably wouldn't be my first recommendation. But if it's a well-known incident and it shows poor judgment, then I think it could.
John Chapman, what are you talking about here with the government imposing its will and searching your house and all that kind of stuff?
I just want to touch base on one more thing. It's I have done a certain amount of employer work in the past in the private sector. I actually had a pretty good result from suggesting criminal complaints to other employees. We had a shop steward that was out of control, and he grabbed a guy by the throat one time and put him up against a wall, and we gave him 2 weeks off for that. And it was split by an arbitrator. And we posted on our bulletin board, sorry, folks, here's the arbitration decision. We apparently aren't able to protect you from this. This is the local police department's number. This is the definition of assault. We're sorry, we can't help you about that. And maybe these guys can. They decertified the union. They didn't think that the union was doing a great job for them if they were defending the right of the shop steward to choke fellow employees. Fourth Amendment stuff, you may find that you have, there may be, your premises may be used for stuff that's bad, trafficking in drugs. We've actually had a case up north where there were some deputy sheriffs, I believe, that were involved in a marijuana growing operation, which now is sort of more legal than it was. But there may be things that you're afraid you aren't able to generate the evidence for, but you're pretty sure is happening. You may have emails on your employer server, or there's a case called Quan versus, I think it's County of Los Angeles or something, that says you own that stuff. That they don't have a right of privacy against you in using that stuff. If you've got enough to generate probable cause to search somebody's house or somebody's boat that's not on your premises, that's not employer property, you can basically drop a dime on them and get a lot of things done. If an agency has the ability to do a search warrant, they'll do it. They'll do the dirty work, but they've got to be given adequate stuff to do that with. And sometimes you even find that with people stealing from the union, and we're tearing our hair out. What do we do about this person? And we collaborate with local law enforcement to get that information to them and get them caught. So that's what I was talking about. You have that. You may not think you have enough to ding somebody, but a search warrant may get that for you, and you may find you don't have the stuff, but you have enough to generate a warrant that will get the stuff.
And I think you end with bad mouthing, bad references, and I think this ties into my example on the performance evaluations. This what's in writing and what's not in writing, and what people don't talk about, but that stuff has real world effects on the employees.
And there is a statutory privilege for references that are given. And one of the things, back when we were all one happy family, I can tell you I really enjoyed practicing with Dan, and our being in separate firms was not the result of either of our activities. But one of the things I did back when we were all one big happy family was to sue an employer that had given a good reference to somebody that was a thief. I think that you're in interesting territory where you're aware as an employer of stuff that the employee is doing, maybe not in your workplace, but that would affect what they're applying. If they're a trash collector, which is public employment in many places, probably their proclivity towards looking at illegal images of minors isn't as big a deal. You may have heard that it's going on and so forth. But if somebody calls you from a child care outfit and says, what do you think of this person? It ought to be either you're going to tell the truth or point them towards some place where they can find the truth, or say no comment with all that implies. There's a no comment reference is a major red flag, and your HR people ought to be trained to use that if they don't know enough to say something really bad about somebody, but they suspect it. That's a no comment situation. Sorry, not going to give that person a reference at all. They work from this date to this date.
The liability concerns, everyone's got to be a little bit concerned about behavior that could come and diminish the reputation of a business or an agency or the licensing of a facility and so on and so forth. You run into any of those cases?
Which one are you talking to?
Both of you.
Okay. John, go first.
Yeah, I haven't really run into those. Certainly we have whistleblowing cases and other issues like that, but defamation really it doesn't come up. EEO, we deal with the Maine Human Rights Commission all the time, but nothing along the line that you appear to be referencing.
There's an interesting case that I came across today out of the district court in Maine, Ellis versus Shirakawa, that is an employee versus employee libel suit. And the flip side was the anti-SLAPP suit that came back the other way. A person had gotten somebody either censured or fired from employment, and the male alleged harasser sued the female, and she actually was successful in an anti-SLAPP suit back the other way, saying, well, no, wait, this is petition. I petition the Maine Human Rights Commission and other public entities, and this is just to shut me up. So there's that. Obviously, you can be liable if you take action against somebody based upon outside of work stuff. The case that I think I've discussed it with Dan. I had a case where a union member, on his own time, on his own devices, from his home, not at work, outside work hours, on his day off, was investigating a grievance. And he called up somebody that worked at the workplace to talk about what they'd seen. And the person was a pain about it. And he used the phrase, eat a dick. That's the actual phrase used to the member. That's like, shut up. You're being a pain about this. I'm just trying to get some questions answered. I'm not here for you. And he used that to, in essence, say, shut up. I don't care what you're saying. And we were gearing up to sue management when they were ready to take action against our union guy, because he was doing what he has to do. We have the obligation to handle grievances in good faith, consistent with the interests of the bargaining unit as a whole. And where management squashes that and causes damage to people, they can end up liable to members, and they can end up, being liable for lost wages, a variety of stuff. There's one that I'm handling right now where a guy agreed to a license suspension based upon a lie from management. Management basically told a lie about this guy, and he was decertified as a correction officer for a time. He didn't want to fight two battles at once. He said, yeah, I know he's accused me of a crime. That's BS. I can beat that, and I will, and he did. And he lost a lot of time that he couldn't work at a correction facility because he was clearing his name. I think they're going to pay for attorney's fees in the defending the criminal act, and lost wages, a lot of kinds of things. So if you take action based upon somebody's off-duty conduct, and it's not protected by the various good faith privileges, Tort Claims Act, discretionary immunity, all those kinds of things, or prosecutorial immunity, you may end up liable to the person that you have said bad things about.
So moving to union activity, union as a victim, violation of union rules, we've kind of covered a bit of that. I put in limits of required representation because I run into this constantly, where you have OUI as a case, T-cert before MCJA. This is not strictly union work, and where do you draw the line on going over and representing people and so on and so forth in forums that frankly become a lot more expensive than dealing it in the cookie cutter kind of grievance, and you know the people on the other side and all that kind of stuff. So that tension exists all the time, and then you're going to have, you know, employees who think you should represent them to the end of the earth, and you have other employees in the same union who don't like that guy, or think he's being overly selfish, or that's his problem. The classic case, it would be a criminal case brought against a cop, where it's like, yeah, we don't like criminals here, and what obligation do you have? And obviously, you know, you don't go there. It's because that's not what you're paying for. You know, the people who aren't getting arrested don't want their dues to be paid for that work. Otherwise, you can get into bigger issues, and you have to deal with, you know, whatever administrative agencies you're dealing with, that you want to go and fight some fights because it's going to have a fallout effect on the other union members as you go along. The Stericycle case, this is, Anne-Marie brought this to our attention. This is a new NLRB case, and it talks, you know, this goes to, you know, the limits on speech, if any, when you're involved in concerted activity. In its decision, the NLRB clarified that an employer's policy or rule that concerns any concerted activity will be interpreted from the perspective of the employee on a case-by-case basis without regard for the employer's supposed intent in adopting its workplace rule. So emphasize from the employee's perspective, not the rule. So you could have an employer operating in perfectly good faith, no intent to harm the union at all, but if it's perceived by the union leaders as something rubbing up against their rights, then there's a cause of action. I think that Stericycle case is in the last year or so, because people want to know that as well. John Hamer, interaction with social media.
So social media is one of those areas that sometimes employers love to try to regulate, and it's very difficult to do so. You know, if it's a matter of regulating speech that's being made on behalf of the employer itself, that's very easy. The employer is free to control its own statements. But when you're dealing with employees who have their own social media accounts, and your intent is to regulate their off-duty use of social media, it becomes very difficult, and it can be a source of trouble for an employer. You know, even having a policy, well, you first off, if you're going to even try it, you have to have a written policy, and the written policy had better be a good one. It has to be specific, and it has to be related to your legitimate objectives of the employer. So I think number 2 there talks about nexus to the workplace. So that's really important. Why do you want to regulate an employee's personal use of social media? If it's going to impact their ability to do the job, that's fine. If you're going to restrict them from having, again, because of Stericycle and some of the other precedents, even prohibiting the use of a video from inside your facility, or a display of your company logo, all these things at one point you could prohibit, and now you can't. And really, it's a matter of a pendulum effect, because when I started dealing with social media way back when, the rules were as restrictive as they are now, and then the administrations changed and they allowed greater regulation of employees' use of social media, and now we're back to where we used to be. And so that means that a lot of employers may have regulate rules out there or policies that are no longer good and should be re-examined. Anytime that you're dealing with any kind of speech from an employee, whether you're public sector or private sector, you just have to be really careful. It has to be a reason why you want to regulate what they're saying. And as John Chapman said on a couple occasions, prohibiting disparagement of your product or your brand, that's fine. But if you're moving beyond that, and then you're opening yourself up to some potential liability. The different ages and social sensibilities, that's a very good Harvard Review article, which I had the opportunity to read, and it points out a lot of the things that we've learned since COVID, really, and it has to do a lot with the merging of your work life with your private life, and it discusses I guess the blending of the workplace, because nowadays you can have people working remotely and it's fairly common for that to happen. So it raises the questions of, where does the workday end? Where is the workplace? And it does suggest that an employer may have a greater need to regulate some off-duty conduct, because the off-duty conduct may or may not actually be off-duty because of remote work. So I guess that article is definitely worth a read. I'm not really giving it justice, so I'm going to ask John Chapman if he has any thoughts about it.
One of the things that, as you were talking, I realized that disparaging one's brand, if it's pure disparagement, this product sucks, you're probably going to be on pretty good ground disciplining somebody for that. You may find the union is an ally. But as I was getting sort of a picture in my mind of somebody who is tap dancing to get to a goal, except he's got to go through one of those minefields in Ukraine where there's a mine every 3 feet. And your HR people and your supervisors have to know where the mines are. And one of those is the whistleblower, what we call the whistleblower, the feds call it the Whistleblower Protection Act. We have a protection for employees who refuse to commit unsafe acts. There's a certain amount of product disparagement that's going to be protected if it is that it's going to poison a kid or collapse a bridge or something like that. So when people are disclosing that stuff outside of work, or maybe even inside of work, you got to know where the mines are. Attending something like this, getting sort of a punch list, even a checklist. Is it going to violate this, 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 and you get all the way to the end, and you have checked all the boxes and it doesn't violate any of them, then you can take some action. That's not a bad idea to do when you've got somebody, especially in the union context, crashing your workplace. Employees have to be approached gingerly about that, because there's a lot that they can say. There's a lot that they can say, especially if they're governmental employees, because everything you do is going to be state action. That said, one of the things you can do is you can stick the government on one of your employees. And we talked about that earlier, but specifically Stericycle and some of these other places, you have people that are, for the Boeing case is the example. That was the old standard where they talked about, in essence, disclosing what amounted to military secrets. It's one thing if you try to discipline them. It's another if you have the Department of Defense taking action against that person. You may just have to, hey, this guy sent this email that showed this picture of that thing. Is that bad? And then wait. You may have to do nothing else at all. If you've got a real serious interest in secrecy, as they did in the Boeing case, and somebody's got no ostensible justification, you might not have to do much at all to get them gone and prosecuted.
Turning to the different ages and social sensibilities, I think the author there uses space and time, which I think John Hayward kind of mentions, is like, where is the workplace now? You're getting emails at 7, 8 o'clock at night. Are you working public sector, private sector? There's points in time in which we're all at work and we go for a walk outside. We're not really in the workplace, but the home is the workplace, and we go for a walk. Where are we? If we use the bathroom, if someone comes over for a cup of coffee in the middle of the day and we're doing obnoxious stuff or whatever it happens, where is the workplace under that? And I think that's the point of his article is, it has to get modernized. I also, social sensibilities, and with some older folks were talking the other day in preparing for this, John uses the Eda Blank topic, which people my age don't use. I find it's a little bit, I'm not prudish, but that just hits me as, kind of offensive, et cetera, but we got to remember, what about if you're 25 years old? And they use that expression all the time, and they're so inured to it, it really doesn't mean a whole lot to them. So I think we have to just be conscious of those things as time goes by and where we're going to end up with those. Continuing, well, here's an example from that article. I know John Chapman wants to talk about this one. A school bus driver is arrested for possession of marijuana after marijuana is found in his personal vehicle during a traffic stop. He is charged by the police with a misdemeanor. The school board wants to terminate his employment after parents complain that it may not be safe for their children to ride to school on a bus with a driver who likes to get high. What do you do with that one?
Marijuana is a particularly interesting drug. I am the designated marijuana expert, not because I am consuming it at all since college, but because I read up on it a lot, because everybody in the police, fire, and rescue industry wants to know more about it all the time, because things are changing all the time. And it varies a lot from state to state. If you do business in more than one state, Rhode Island actually has almost a Bill of Rights for its recreational marijuana users. Maine, less so. Both places say you don't have to accommodate it in the workplace, or you don't have to accommodate somebody who's stoned. And this stuff, depending on which medical journal article you read, can cause, unlike things like cocaine and so forth that are more traditionally water soluble, THC is fat soluble, and you can detect in a moderate user measurable ripples in your neurocognition 28 days out. So that's a big deal. I guess the probable thing that you should do is, first you should, if you hear that, especially if they're popped for marijuana use, you want to make sure everybody knows what the rules are, because you don't have to tolerate it in the workplace. And at least I think it's in Rhode Island, it's like for 12 hours before. And the next question is, regardless of everybody else, how does it affect them? And maybe an investigation is worth doing, because at that point, if you do nothing and you know they're using something that might affect them on duty, it's going to be a problem. If there's an accident, they're going to be saying it's you. And if you take job action, they're going to be saying this is no just cause, it was all off duty, and so forth. So I think you're going to actually have to show that it's going to be a problem for them. The one current exception to that is law enforcement, because except in New Jersey, the New Jersey Attorney General went on record as saying that off-duty recreational marijuana use was not something you could ding somebody for who's a police officer. The ATF would beg to differ, because if you are a user of marijuana, then you are a prohibited person. That said, there's at least 3 drugs now that are pure THC, that are synthetic, that are FDA approved for treating certain conditions. And so you're going to want to go through the checklist. Are they using it? Are they using it on the job? Does it indicate something about general lawlessness, the way they're using it? Or are they using it legally? And is there something about just their employment that's going to be a problem with them being a user of it at all? And it's a medical question. If people think that they're all over the road, whether or not it's caused by the marijuana they smoked 2 days ago is not an issue. And you might actually do an investigation and have a medical evaluation and find out, gosh, it's they have some kind of a central nervous system problem. I had an employee that I was dealing with that had that. Everybody thought he was a coward. Actually, he wasn't going into certain hot calls. Turned out he was mentally vapor locking at them. If you discover that somebody's unable to do the core functions of the job, it doesn't matter that it's for something illegal. You may start to investigate thing A, end up at thing B, but you're going to want to be able to document that this isn't just, we're not just trying to get the person because they used marijuana. Here's a video of them all over the road. We have videos on all of our buses, and this is everybody else's, and this is his, and it's pretty much every day. So those are the kinds of things that you would be thinking about.
Right. The hard case, however, is he's not all over the road, and yet you're going to have the parents at the school board, going crazy. The other thing is, what if you are smoking pot in Alabama and you live in Denver, and you get arrested in Alabama, out of the jurisdiction, but you work in Denver. How do you play that?
That's one of the interesting MCGAA things, because there are things that you could use in Alabama that would not be illegal to use in Maine. And if you have the same conduct that is, criminal, maybe even felony there, that's not bad at all here, that's going to be an interesting thing to deal with. Maybe you submit it to a licensing agency or a certification agency and say, what the hell do you think? The one thing you're not going to want to do is to pretend it doesn't exist. The ideal thing, I think, is you're going to want to do something appropriate with it.
From my perspective, if a person is in another state doing something illegal and they know it's illegal, then that shows lack of judgment, of good judgment. So I think that's, and especially if you're talking about a police officer, then that's going to be a real problem. If it's someone who's working in public works, maybe not as much, but still the intentional willingness to violate another jurisdiction's law, to me, is just as bad as doing it here in Maine and violating law.
Well, John Hamer, what if they didn't really appreciate, they just got off the plane, they didn't know the jurisdictional differences and so on and so forth. So you take intent to violate the law out of the equation.
Sure, that's a circumstance to consider. If the person truly didn't know that it was illegal, then there was no intent. Maybe the judgment is not as bad if it's illegal, if the conduct is legal in Maine and it's not legal there. So for me, it's a matter of, are they disregarding known law? And if that's a decision they made, then that's bad judgment. If they just didn't understand, then that's something you can consider.
And John Chapman, what if they're they're not a police officer, you know, whatever, they, work at a clerk's office, they collect garbage but they're still in the private sector and they do something illegal out of state, you know, not murder or anything like that, but you know, if there's an issue out there, how about not reporting it to your employer? I mean, do you have to report it to the employer absent?
Oh, you mean if you're the employee?
Correct.
Well, if it's that's an interesting triage question because you're probably in the private sector an employee at will, or maybe you're a probationary employee. If what you're doing isn't protected activity, you can be fired for it. And the question is, how are they likely to react to it? If it happened 2 years before, you never said a word about it, never said that it did or didn't happen, and somebody tries to fire you for it later, even if you're a private sector non-union, it probably won't be found to be misconduct under the unemployment laws. If it doesn't have that amount of nexus to your employment, they're still going to get unemployment. And of course, you add in just cause. The really interesting thing to me, Rhode Island actually allows you to lie on your employment application if you've had your conviction expunged because of marijuana use, except for they have like 5 or 6 employment categories that you have to tell the truth about it for. Really, you can't make this stuff up. And the rest, you're entitled to put down in your application by statute that you've never been convicted of a criminal offense. Figure that out. That's what happens in Rhode Island.
I have a
By
question in the
statute.
chat. What about the situation in which an employee thinks the employer has done something inappropriate and reports it on his own time and unknown to the employer to a higher authority? Is the employee's action off duty?
I don't know that it matters so much if it's off duty or not. It sounds like the act of reporting what they believe to be a violation of law is going to be protected, or violation of a rule, even if they're wrong. I mean, that's general whistleblowing. So for me, the salient question is was a report made? And if the report was made, I don't care if it was made on duty or off duty. And maybe I missed the point of the question.
And I agree with you. I think that the question is primarily, is it protected, the report? And in fact, there might be more of an obligation to report it if you're on duty.
All right. Did John or John, you have anything else you want to say today?
Not that wouldn't take an entire additional day to lay out.
Okay. All right. I just want to give you a cite from the case that John referenced, which we consider the outer limits of behavior and what you can do and say and so on and so forth. That was Pier 60, that's 60 LLC NLRB 855 F3rd 115 if it matters. That's the 2017 case where during a break, Mr. Perez says some terrible things, blah, 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 and does not get in trouble. So I can get you that site if you're interested. But otherwise, I think that's about it.
Thank you for having me today.
Okay.
Thank you, Dan.
Thank you all, and someone will stop the